I'd like to talk briefly about the process of formally being charged with a crime in the criminal law system, and that is what is commonly called being arraigned. That's the term of art in the criminal system. It says you're going to go in for an arraignment. That means you're going to be formally charged with a crime and told what's going on. And from my perspective as a criminal defense attorney, there's a couple things that are important that people should know about when they enter and when they're being arraigned. First of all, it's really a formal process. The prosecutor is going to tell you what they've decided to charge you with, and a judge wants to make sure you understand what's going on, and they want you to enter a plea of guilty or not guilty to that charge, and it's a pretty simple process on that level. There are some other issues, but these are the primary issues that I think people want to know about. The other thing that they're going to do is they're going to set, and that would be the judge, is going to set conditions of release during the pendency of your case. Even though you're presumed innocent until proven guilty, you have been charged with a crime, and a judge needs to consider factors like flight risk, whether you're going to run away, whether or not you represent a danger to the community, whether or not your behavior will remain peaceful and logical and rational during the pendency of the case, and what does a judge need to do to assure that that's going to happen. So a judge can enter bail on these when you're being arraigned as a condition of release. That's pretty typical. In some cases, judges can order that you report to somebody on a daily basis. They can order electronic home monitoring. They can order that you abstain from using drugs or alcohol. They can order that you stay away from an alleged victim or a witness. A judge can order a lot of things. There's a broad discretion of what a judge can order during the pendency after you've been arraigned as a condition of you staying out of jail. And remember, when a judge orders you to not do things as a condition of release, the only other option they have, if you won't abide by those conditions of release, is put you in jail. A common question is, can you waive an arraignment? And the answer in the state of Washington is, at least on felonies you cannot. On misdemeanors you can. There are 3 types of misdemeanors in general you cannot waive, or gross misdemeanors you cannot waive an arraignment on. And that's crimes that involve DUIs, driving under the influence, crimes that involve weapons, and crimes that involve domestic violence, i.e. Problems in close personal relationships, like spouses, people related to you by blood and marriage, stepchildren, children, roommates. Well, the list goes on. There's a statutory definition, but I think that gives you an idea. The logic, I think, behind that is that in domestic violence cases, the court system has to mandatorily consider entering an order separating the parties. They don't want any more problems in domestic violence situations, so the court has to consider to do that, so they need you in a courtroom so they can order you to do that formally. In DUI cases and cases like this, they want to make sure that they can certainly at minimum order that you abstain from alcohol, you don't drink. If you've just got a DUI, they want to tell you during the pendency of the case, don't drink, which kind of makes sense. And then in crimes involving weapons, certainly want to restrict you from having any other weapons during the pendency of the case. That's my perception of the logic behind these things. But a common question also is, will I get taken into custody during the pendency of an arraignment? And of course you can get taken into custody if a judge orders bail at that arraignment and doesn't give you time to post it. So, but there are arrangements can be made in advance to make sure that bail is available, and any time you spend in jail be very short. There can also be in felonies. If you're charged with a felony, they want your fingerprints and they want some other identifying information. In the state of Washington, that's generally done at the jail. And if they have not gotten that information in advance, after they arraign you, they'll take you into custody for a brief period of time to get that information and process you and then release you. There are ways to do that in advance, but you'd have to talk to your lawyer about that. And then last but least, of course, you screwed up. I mean, if you show up at a courtroom intoxicated, if you have other charges pending against you, if you have a warrant against you, certainly you're going to get taken into custody. But that seems kind of self-evident. That seems kind of self-evident. And then I think the last common question people have is, hey, what do I do? How do I act in a courtroom? What time should I show up? And the answer on that one is show up early because you don't know where you're going. In courtrooms, you show up on time. That's the rules. It's a very formal process. It's kind of like showing up late at church. You don't want to be that guy or that gal. In terms of what to wear, I often tell people, if you go to church, what you'd wear to church is probably appropriate for what you would wear in a courtroom. Unless you're used to wearing a suit like a lawyer is, it probably is not the ideal thing for you to wear. But you want to wear something formal. You don't want to wear anything with a slogan that's inappropriate, although that seems self-evident. In some cases, people feel strongly about things and they want to do that. The idea is not to stand out and to make an impression in how you dress and look in a courtroom where impressions are all that a judge has, or one aspect of what a judge has to making a decision on what they're going to do with you and what kind of bail they need to set. And then last but least, of course, be respectful of the process. If you have a criminal defense attorney, you probably are not going to need to talk much in the courtroom. There's a minimum number of yes, no, and pretty simple questions you have to have, and you'd follow the lead of your criminal defense attorney in that process, and they would probably have talked to you in advance about what's going on. And then a common issue, but easily forgotten, is you need to turn your phone off. In today's world with cell phones, there are some judges that will just simply take the cell phone. There's signs on the wall that says that in every courtroom, don't have things that make noise for obvious reasons. It's kind of, again, I use a church as an example. You don't want to be that guy or that girl having that happen. So I think this kind of gives a general overview of, or at least my perspective on being charged, what that means, what's going on in the process. I hope this helps.